Recording has begun. Supervisor Joya is delayed with his previous meeting, but he'll be joining us shortly. In the meantime, I figured that we could start with a round of introductions, make sure we're all familiar with one another as we get to work. And then we can hear from County Council, represented here by Tom Geiger. Good morning, Tom. And he can give an overview of the draft ordinance. At which point, my expectation is that Supervisor Joy will be joining us as well. And I should take my own advice and his advice and call him John. So John will be joining us. Okay, so with that, let's do a round of introductions. And the way we can do this is I'll go ahead and call on the next person since I see everyone on their screens. Please give your name and your interest in this meeting and in the tree ordinance draft. And basically, what you're hoping to get out of this moving forward, and be relatively concise. So my name is Robert Rogers. I work for County Supervisor John Joya, and I'm here to work together to find out what we can do to ensure that we get the best draft ordinance moving forward for the tree issue. Because as you might all know, this is something that comes up quite often, not only for everyone here, but for us here at our office as well. So we want to get this input and be able to move forward as effectively as possible. So with that, I apologize, I'll just kind of call on people. And why don't we go with Wendy Lane?
Okay, good morning. I'm Wendy Lane. I'm a 30+ year resident of Kensington. I live on Trinity Avenue, and I'm hoping to get out of this some clear, actionable guidelines for residents, ideally with some teeth, but ideally something that's easy to follow. So anyway, and I guess my interest, I'm thinking like everyone else, because I'm a longtime resident, my view has been obstructed, and so I'm interested and understand there are, pros and cons, and it's a complex issue. But anyway, thank you.
Thank you, Wendy. And how about, I apologize if I mispronounce, but is it Shira?
Hi, everybody. I'm Shira. I've lived in Kensington now almost 12 years. There is a very beautiful coast live oak in the backyard, one of the reasons why we bought the house. I did not know about the view ordinance when we moved here. So I've been working very cooperatively with the neighbors upslope, and because they have been trimming this tree for a lot of years before we moved here. But I'm looking to get some clarity also, I think that seems to be the key word, around issues that affect the topography of Kensington, namely the underground creeks that we have here, soil stability, we are on a slope, and also how the ordinance intersects with the protected trees, given that the coast live oak is under that designation. So sort of like we tick all of those boxes, and yet people lop off branches on their side of the fence, they lop off branches on the top. I just kind of want to understand. I mean, I have an interest in being a good neighbor, but I also have an interest in protecting the tree and the topography of Kensington.
Thank you very much, Shira. How about Catherine?
Hi, I'm Catherine Deniergard. I'm a very long time resident of Kensington, more than 50 years, and live also on the hillside on Highland. And I'm very interested in this topic so that we could have an ordinance that, as Wendy said, has teeth and can be fair to both parties, and also clarify certain points that I'll go into later. Very excited that the supervisor has gotten this work forward. Thank you.
Thank you, Catherine. How about Candy?
Hello, my name's Candy Capagrossi, and in the spirit of full disclosure, I'm wearing two hats. I am a member of the Kensington Property Owner Association, and I am also an owner of a home that the view that I had when I moved in is now totally blocked, and I've been trying to work cooperatively for probably the last 8 years with my neighbor. So I see that Gail is here also representing KPOA, so she'll probably be slightly more neutral than me. Thank you.
Thank you, Candy. And let's follow that segue. Gail, please.
Hi, everybody. Gail Feldman. And as Candy mentioned, I'm also on the board of the Kensington Property Owners Association. Lived in Kensington for 28 years. Yeah, I've been, as the former president of the Property Owners Association, I have given out much advice and, guidance to people regarding the ordinance who've called us to find out more about it and how it worked. And then I heard all the stories from people who had unfortunately bad situations with a neighbor regarding a tree. And so I'm really hoping through this process, we can amend the ordinance so that there's at least some additional processes that people can use, try to resolve the conflicts they might have regarding the trees before they go to expensive litigation. And so I'm happy that we're moving this forward, and I'm happy to talk about the draft once we get to that point.
This person now is going to be sold.
Thank you, Gail. How about Ali?
Yes, hi, can you hear me?
Yes, thank you, Ali.
Okay, good, because my computer is old, so it's not working very well. I am Ali Al-Yami, and this is Terry Al-Yami next to me. We have lived here for 42 years, except for one house. All the houses around us have been sold 3-4 times. So we have to deal with different people constantly. Our main interest in this is used to be mostly our view have been obstructed, like many people in this group. But now it is fire, it is affecting the value of the property. We have a new neighbors that we can discuss and deal with them, but there are others who would never compromise or agree to anything. And that's what the big issue for us is. How do you deal with somebody who seems to be totally ambivalent, but not interested in entering into any conversation about the issues that confirming that affecting all of us. But so now our interest is not just the view, it's the fires, it's the climate change, it's the dangers that is affecting the whole state, actually. Thank you.
Thank you very much, Ali. Well said. And let's move to Michael.
Well, thank you, everyone. I am also a resident on Highland. We've been here about 18 years. Having had a background with the ordinance in Los Gatos, as well as some of the few communities throughout California, we felt it was worthwhile to look into the Kensington view ordinance, see how it was originally defined, and look at the opportunities for preservation of trees through maintenance that maintains views. This is not about ridding trees, never really has been. But I think that most of us bought into this neighborhood for the right or for our views, and we were given these rights to maintain those things. They have to be done in constructive ways for heritage trees and other things. But the overall sense is replantings and other things were written well into the guidelines. We did some research in regards to finding all communities in California that have view ordinances. We put together about 15 different cities that have an outline to that. We looked at all of the different structures of how those were enforced or carried out. Some are done through elements of homeowners association groups and other things. But through that, Tom Geiger and John in general have really just given us some great outline on how this could be cooperatively accomplished through neighbor relationships. And I think that those are really important things to build on to get this moving forward and keeping things going in a very neighborly fashion. For Kensington is a special place in regards to its ability to have these sorts of boards in place. And so we really felt that encouraging that and getting that moved forward with a better structured outline in regards to what the tree TOV really means to our community. So I think we've again have looked at those 12 outlines. Tom has put together something here that I'm very impressed with. Again, thank you all for your time and all being involved.
Thank you, Michael. And yes, I think we all agree Kensington is a great and special place. And I'm happy to announce John is able to join us now. Hi, John.
Sorry, I was in another meeting. My meetings are running over here this morning. But so what have you covered so far? Has Tom gone over?
No, John, we're about 3/4 of the way through introductions.
Got it. Okay. And so I thought Michael was giving a little introduction about some of this. So thanks. I caught Michael's comment. So, okay. So we'll just go through the rest of the introductions.
Wonderful. Thank you. How about Monica?
Hi, good morning, everybody. I'm pretty much echoing what everybody else has said. I'm a resident of Kensington for 35 years. And right now, I started living on Cambridge, and then I have now moved to Norwood. And we have two other neighbors. We have a big redwood tree in front of us that is blocking my view and two other neighbors' views, and historically has been windowed before. And now the owner does not want to be cooperative and let us, like do any windowing or trimming. So I do realize, I do appreciate, the tree landscape in Kensington, but I think a lot of emphasis has been placed on the trees and not enough for the view. And I'm just here to see, to learn about whether we can strike a good balance, like where we can restore our views without being too intrusive on the tree landscape.
Yes. Yes, challenging, strike that balance. Thank you, Monica. Curtis.
Hi, Curtis Keller. I'm a deputy in the county council's office.
Wonderful. Thank you, Curtis. And Mark.
Yes, I'm Mark Wagner. My wife and I have lived in Kensington for 26 years. We have a neighbor on the west of us, and the house is being renovated, and we believe it is going to be put up for sale. It has several very healthy live oak trees on the property, which are rapidly obscuring our view of the western horizon. These trees were minuscule when we moved in, and now they're getting to be quite large, and they will continue to grow quite large. The current owner of the house lives on the East Coast. He is rather an odd individual and probably very difficult to work with. And what I was saying, the house is probably going to be put up for sale, and we are interested in how this tree ordinance would affect a situation like this where the house is going to rapidly go into new ownership.
Thank you, Mark. John, obviously you need no introduction, but if you'd like to, please do.
Hi, John Joya, Board of Supervisors, and I just want to thank everyone for their patience as we took longer to schedule this meeting after County Council had gotten us the draft, but we're looking forward to hearing everybody's reactions and moving forward. So we should probably move into the presentation by County Council. That's what we really want to hear. And I know I got emailed a few questions, and I know Shira, you had a question that you had emailed me about. I mean, you'll have a chance to ask that. Virginia Steffen and Diane Eggleston also had questions, but they're not here, so I'll ask them from their email once we go through the presentation.
Thank you, John, and thanks everybody for introductions. We've done them all, save one, and that would be Tom with County Council. Tom, please introduce yourself and then take it away with your presentation.
Okay, sure. Yeah, I'm Tom Geiger in the County Council's office. Curtis and I prepared this latest draft that we sent around, and basically what it does is it adds to the existing procedures of the TOV ordinance, and there's more county involvement in the process now. So I can just kind of briefly go through these procedures. The first step in the procedure is it's called the initial reconciliation, and that's in the existing ordinance. And it's basically tries to get neighbors to work together to work out a solution informally without any involvement by the courts or the county. And that's in the existing ordinance. The first step that's new is the voluntary mediation step. And in that step, the person whose view is being blocked can request that the tree owner enter into voluntary mediation. And then there's procedures for going through that. And then hopefully if they engage a mediator, the mediator will be able to help the two sides work out a solution that everybody agrees with. The third step is, and that's if the initial reconciliation process doesn't work or the mediation doesn't work, either the person whose view is being blocked, who's called the claimant in the ordinance, or the tree owner, can offer to go to binding arbitration. And so if the sides agree, whatever decision the arbitrator makes is final. And then to do that, the person who initiates the request has to establish a view claim. And so those are laid out in the ordinance. It's on page 6 of the ordinance. It has to explain how the view is being obstructed, where the trees are located, what the two parties propose to resolve the problem, and a showing that they've tried to work things out among themselves and it hasn't worked. And so if you go to binding arbitration, that's before a tree arbitration board. And that's something that the Board of Supervisors would create. And I think, John, you had talked about in Kensington, probably the MAC would be designated as the tree arbitration board in the Kensington area.
We could, yeah. So I was going to ask you about that. We could either then set up a separate tree arbitration board, or we could designate the MAC, right? We could do either of those.
Either one, yeah.
Right.
Yeah. So that would be up to you and the board, but yeah, those are the two options. And then if the parties don't agree through initial reconciliation, don't work something out with a mediator, and the parties don't agree to binding arbitration, then either the claimant or the tree owner can just go before a tree arbitration board on their own and get a advisory decision from that board. And so that it would work kind of like an arbitration hearing, but it would be an advisory opinion. And then
can you go back on that, explain
Sure.
that one further?
Sure. So if the two sides don't agree to any of the other steps, either side can just say, well, I want to go in front of the tree arbitration board and make my case. And so in most cases, that would probably be the person whose view is being blocked. They would go and establish their claim. And it is advisory, but I think the good thing about that is that if this does end up in court, that decision of the tree arbitration board is a rebuttable presumption that that a court would have to follow if there was.
But on what basis would a court consider that a rebuttable presumption? Because we can't tell the court to make it a rebuttable presumption, right?
No, but it is, well, the ordinance says it's a rebuttable presumption. So in that case, then the court would have to look, I mean, the other side could come in and say, well, even though that's presumption, here's my evidence why there should be a different
What
decision.
happens if just one side goes to the tree arbitration board to make their case and the other side does not?
Well, then it's going to be pretty easy to get that rebuttable presumption. But but it's something that the person whose view is being blocked could take to court. But they would be suing their neighbor, and then at that point, the neighbor would come in, and it would be litigation.
Right. But I mean, how would a court look at? I'm just wondering, how would a court look at a fact-finding decision where only one party made the presentation?
I think it would depend on the facts. I mean, if it's pretty clear that a view is being blocked and there's not much on the other side, I think the court would consider it. But you're right, I think the court would also consider that the other side didn't even show up in front of the fact-finding board. But it doesn't direct the court to rule a certain way, but it's evidence kind of in favor of the person who goes to court.
What's the various causes of action? We don't go into detail on that because that's the sort of what the law is.
Right. I think the main one would be a private nuisance cause of action. It's like, the blocking of my view is a nuisance to me. That would be the main one, I think. I think the problem is, that we've talked about since the beginning is under California law, there's no complete right to an unobstructed view over somebody else's property.
Mm-hmm.
So litigation, I mean, hopefully it doesn't go to litigation, and hopefully this is a new procedure that lets everybody work everything out without going to court. Right. But, litigation can get messy.
Tom, what impact, if any, does our general plan policy with regard to considering views in a development play into this? I know we have, of course, general plan policy and the zoning ordinance that, for small lot review, not small lot review, but for any basic development in Kensington, views is of value, at least to be considered and somewhat protected with regard to development. Doesn't mean someone can't build a development that affects somebody's view. So does that general plan policy have any influence in this type of court proceeding?
It does. I mean, I think the person whose view is being blocked can bring that up. And I think that, it's a policy and it recognizes that views are important, but it doesn't, mean that somebody, like I said, somebody gets an automatic right to an obstructive view. And I think this ordinance as well at the beginning stresses that views are important. And so does the Kensington overlay ordinance. So, those are all consistent with that general plan policy.
Got it. Anything else you want to cover before we move to questions?
I think those are the big changes. We did model it after the Sausalito ordinance, which, I think a lot of people here said was a good model. And, like I said, the basic thing is to have more county involvement in the procedures to get people to work things out, hopefully.
Okay. So we'll just go to questions now, right? Good.
Okay, I see. What we can do here is you could either raise your hand or you could hit the raise hand button, and that can keep us orderly. I know we have a lot of questions we want to get through. And the raised hand button is best because it orders when you put it up. And so I'll just go in order in which it was received. So with that, I see Candy is up first.
I wanted to add my thanks to everyone's thanks for all the work you've done on this. And I know it's very tricky business. I wanted to add a comment that although this is primarily about views and trees, you know, in the last 10 to 15 years, many of us have gotten solar panels and trees and invested quite a bit of money in doing that to try to help the environment. And many of these trees are blocking that access. So while that's not necessarily part of this, I think it's an important consideration. And my second question, which that wasn't a question, a comment, but my question would be, if we have years of documentation of attempting, would you recommend that we start this process all over again as a fresh, trying to reach out, go through all the steps? Just curious about that.
And, you know, rather than bank all the questions to be answered at once, maybe we should take them ad hoc as they come in.
Yeah.
So with that, Tom?
I think, you know, years of trying to work things out is good evidence. And I think that would definitely, you know, if there's an arbitration board looking at that, I think that that would be useful to bring up. I think that probably before somebody were to go before one of these new boards, you would want to make, you know, one more attempt, at least at the initial reconciliation. So you know, you have the history of what you've done, and then you know, also done something recently.
Okay, thank you.
Thank you. Next up, Catherine.
Oh, before we move on, I wanted to follow up on a question that was asked. And what protections are there, Tom, for situations where trees impact a neighbor's solar panels?
You know, I think that there may be some protections in state law. I think that, you know, before we take this to the planning commission and the board, we just want to double check and see how that affects it. You know, there is kind of a tension between, you know, everybody wanting to use solar and the fact that if you have a tree on your own property, you do have a right to have that there. So I think there is that tension. And so, you know, we can, if there's a change we need to add to this ordinance to address solar panels, we can do that.
I just looked up here. There's something called the Solar Shade Control Act. Believe it or not, was signed by Jerry Brown in 1978 to give solar collectors access to sunlight. The act prohibits blocking access to solar collectors by trees on an adjacent property and provides criminal penalties for violation. And the law attracted little attention until 2008, when a dispute in Sunnyvale ended up in court. So looks like it was passed way back in the 70s and is now more relevant with because of the obviously the importance of solar. So there is some.
Does that website say how the court or the case was resolved?
It said the tree owners spent $37,000 on attorney fees before trimming their trees. So I guess they lost.
Yeah, well, and I think that's, you know, a good thing about this ordinance. Hopefully, you know, people can use the ordinance before getting the attorneys involved.
So there's a good website. If you go to Sunlight Solar Inc., they have a little information about this ordinance too, but you can get on the web and there is information on this.
Okay, we'll take a look at that.
Thank you, John. Thank you, Tom. Next question, Catherine.
Yes, I have about 5 tiny questions. Thank you, Tom and John, so much for bringing this forward. The first one concerns the definition of tree. At one point, giant bamboo were planted 5 feet from my house, blocking sunlight and a sort of skyline view, but not really the view. Some view. Well, it did block view. And it seems to me there should be a definition of tree that includes bamboo or just other large foliage. That I think with this ordinance, we don't want attorneys to go too much into the weeds about, well, bamboo isn't really a tree, or you know, other small kind of things, but really want something clear and simple that people can use. So I would appreciate a definition of tree that would include bamboo and other tree-like structures. Bamboo, by the way, besides being thick and spreading, can grow to something like 80 feet tall. The other thing I'm noticing is that at the beginning of the ordinance, the old ordinance, we're talking about sunlight as well as trees, but the sunlight is not really incorporated into the body of the ordinance. And the sunlight is important not only for solar, but also for people trying to grow food or just enjoy sunlight. And I would like that to be a little stronger in the ordinance somehow. Also, I think a factor to be considered in listing factors, again, a judge or arbitrator is going to look at this. And by the way, I'll email all this to you, John. But we should also include wildfire risk of the tree as something to be considered in the arbitration or litigation. And also, we're looking as if there was one claimant, but in many cases there would be multiple claimants, and who all have the same tree obstructing. So I don't know if that needs adjusting, but I'm just noticing that. And now I'm going to have to look at 2.406C, and I have to turn to that. It says, in terms of view character, the character of the view is determined by evaluating, and C is the extent to which the view is diminished by factors other than the tree or trees involved in the claim. And there's an ordinance after that. I'm not sure what the ordinance is. So I have a question about that phrase, 2.406C. What does that mean? What bearing would that have on arbitration or litigation?
Okay, thank you, Catherine.
Yeah, I'm going to speak to some of that, but I do want to speak to a question and then have Tom respond, Robert. So, yeah, Tom, there is another countywide, the issue that was raised on wildfire risk. There is a countywide tree ordinance that's being worked on. I think that's where wildfire and other factors are considered. Can you talk about that?
Sure. Well, I actually don't know where DCD is right now on that revision. And so, we actually haven't seen a draft for a while, but I think that and there are also fire codes that talk about defensible space. So there are a lot of different factors that would be involved in, requiring somebody to take down a tree. So, this ordinance really is just for dealing with views. I think there are like I said, there are other ordinances that deal with wildfire and those things. So there's a clause in here that says that this ordinance basically it doesn't preempt other ordinances. So if there was some kind of fire code that dealt with that we would have to look at the interplay of that.
Yeah, I think it's important to note that this ordinance was focused on view protection, and that there's a lot of in fact, there's issues about historic trees, because that was one of the questions that was asked. Let me pull it up. I think that I think all of those are going to be the subject of a countywide ordinance. Kensington's not going to be treated any differently, I'm just sad to say, than other unincorporated areas that are high severity fire zone. I think we're looking at a countywide ordinance that addresses a lot of those issues, and maybe we need to get an update on that. So I think like for example, one of the questions that was asked was, where is it? Let's see here. Where was it? That, well, maybe that was Shira, your question, which we'll ask was about, are protected trees exempt from this, or do they have the same status as any other tree? my understanding, we need to get an update, is there is, again, this countywide tree ordinance is addressing a larger set of issues on trees. And I have asked them to include the wildfire sort of issues in that as well. So maybe we ought to get an update. So I don't think the wildfire issue is going to be put in this ordinance. You know, that's just a separate issue that's going to be looked at more countywide.
And John, just to one of the questions that you had sent that somebody had before was, how does this ordinance, you know, interact with the tree preservation ordinance?
Yeah.
And so, I mean, I think that that same language that says that other ordinances apply as well. So say, for example, if, you know, there was a tree that's protected under the other ordinance blocking somebody's view, and they went through the process and agreed to, you know, trim the tree to restore a view. Because it's protected, the person who's the tree owner would still have to go and get a tree permit to do that work. So if it's not a tree, protected tree, you don't need a permit from the county, but if it is, you would need to go and get a permit. The tree protection ordinance doesn't say you could never trim or cut down trees. It just says you need to get a permit before you do that.
Right. So basically the tree the other ordinance will define those issues, won't come up in the context of this ordinance. I mean, because this is a civil matter, this goes to court. The judge isn't being asked to rule on, is this a wildfire risk? Is this a heritage tree? The judge is being asked to focus just on views, right?
Right.
Now, Catherine raised an issue that's probably more of a policy issue, and about whether or not we should include access to sunlight. Now, the development ordinance does, you know, that's different. It looks at things like views, access to sunlight, you know, privacy, like parking, other things. The question of whether this ordinance, because it currently doesn't address this, gets expanded to protect someone's right to sunlight, I would substantially broaden this ordinance. I'm not sure whether that's the right thing or not. Be interesting to hear people's thoughts. Tom, do you have any preliminary thoughts about that?
Well, first of all, I mean, I think the language regarding sunlight, that's in the current ordinance as well. So, I mean, I think that's, as a policy statement at the beginning, it recognizes that sunlight access is important, but the remainder of the current ordinance and this ordinance really just focuses on the views. I think, you know, because the earth rotates at different times of the day, you get different amounts of sun. I think that's probably why the current ordinance doesn't really focus on sunlight other than to say that it's an important factor.
I know that when under the development review, you know, when folks are building something, and if it's a big mass and scale, it affects that's being built. And if it's a mass that blocks someone's, let's say, sunlight all day or part of the day, there often is a sun analysis that's done to look at how much does it, right? I know that's been used. I mean, there are different policy issues at stake here, right? I mean, trees, there is a benefit to trees. Many people will argue, you know, the nature of trees is good. You know, it's a different issue than a development. Sunlight is considered in the development ordinance, access to sunlight. Here, there's some trade-offs, and, you know, I suspect you'd get a lot more tree trimming if you had to protect, you know, people's access to sunlight, and, you know, what are the consequences of that? So I think it raises some broader issues. Yeah, so I just want to note that a development is different, right? So I have some hesitation about expanding the policy to consider sunlight. I just do. That's one person's belief. I don't know how people will come out on that. You can express some views, but it would mean a lot more tree trimming, and whether people want to see that is also an interesting question.
I'll just add in, John, that in all the years that I've gotten the calls from people as the president of the Property Owners Association, sunlight was not ever really an issue. So view was.
Yeah. Catherine, did we, I know, so the other questions to ask, the multiple claimants, I mean, the ordinance, it's very legalistic, but there could be multiple claimants. That's not an issue, right? Claimant means any owner. You could have multiple claimants under this ordinance. You can have,
sure. And I mean, I
both
think
neighbors sue on this, right?
Yeah, and I think it's probably more effective if it's, affecting a lot of people, for them to all get together and file one claim with many claimants. So then it's resolved.
Right.
And it's more, it's more evidence in favor that many views are being blocked.
And Tom, can you explain that section, the question that was asked, that section for 2.406 view character? The character review is determined by evaluating the following. Can you that third item C, the extent to which the view is diminished by factors other than the tree involved in the claim, and then it has an ordinance.
Yeah,
like,
that's
how
a big.
would that affect the judge is my question.
Yeah.
What is he supposed to do with that, or she?
Well, yeah, I think, first of all, that's in the existing ordinance as well. But I mean, I think I think a judge would look at it if somebody came in and said, well, my view is being blocked by this tree. And then the person who owned the tree came in and said, well, your view is also blocked by these other things. And even if I cut my tree back, you're still not going to have a good view. So I think it's kind of an offsetting factor.
Wonderful. Thank you, Catherine. Appreciate those questions. You could please lower your hand when you can. And Gail.
Great. Thank you. I just had some questions in regards to the draft ordinance. So I'm just going to go through them. There were just a few comments here. Just pull it up. Oh, so again, with the question that was raised by Catherine, in the existing ordinance, there is a definition of tree, and it doesn't appear to be in the new ordinance. So I'm just wondering if that was an oversight or intentional, but whether that,
Yeah, I was going to ask about that. Where is the definition of tree in the ordinance?
Well, there's a definition in the other ordinance, but we can add that back in. And I think under that definition, bamboo would not be considered a tree, because bamboo doesn't have one main trunk.
So what happens if, I guess, if something other than a tree that's vegetation blocks somebody's view? Including bamboo.
That might almost be like that. Well, I mean, depending on what it was, that might almost just be like a weed nuisance or something. I mean,
well, but let's say it's not. Let's take bamboo.
Right.
So, I mean, if let's say, if bamboo grows high enough and then similarly blocked, shouldn't it be treated the same way?
It probably should. So, I mean, I think that the solution then is to add a definition of tree, not that's in the existing TOV ordinance, but that's in the existing tree protection ordinance. And a tree is defined as a large woody perennial plant with one or more trunks, branches and leaves, not including shrub shaped to tree forms. So I think that would cover tall bamboo because it's got multiple trunks.
Right.
So you'll put,
although some would argue it doesn't have any trunks.
so you'll maybe
we can add that.
Okay, got it.
Great. And then under the definition of view claim, I think you switched it around, so it might be in a latter part of the new draft, but in the old ordinance, the view claim has a definition, and then now there's just one sentence for the definition of view claim.
Well, we did move that around because, and that was just kind of, we don't like to have, regulations in the definition.
Yeah.
So we moved that to the actual regulatory.
Yeah, it's still in there then.
Yeah.
Okay. I thought so. I just wanted to make sure. And then I think my last question is, oh, no, I have two more. So there's in the okay, so in the arbitration before the tree arbitration board, you have an arborist report listed, and I don't know if that's something we need to have as a definition, but I'm not really sure what the is it common? Is it like an arborist report a common thing? Or, I mean, what is it that's going to be in this arborist report?
Well, I think part of it, somebody mentioned earlier about slopes and things like that. I think the arborist report would kind of evaluate what would happen if you trim this tree or do these other things to the tree. What's going to happen to the tree overall?
Do you think it would be important to put that in the definition? I'm just, because I just don't know like what an arborist might put in their report, or what we need to have in the arborist report is really more important, I think, is like, what is it that the arbitration board is going to need from that arborist report?
Well, I think we could add, I mean, I don't know if we would want to define arborist report, although
we define arborist report in a countywide, but it's more
Yeah.
about who prepares an arborist report, qualified individual, those sort of
Right.
things. But we do define it there.
Do you define it as
I
what?
think we could
what
add that. We
included?
could add the definition of arborist into this as well.
Yeah, I think it would be helpful just to be clear on that. And then my last comment is, so under the section on fact finding and advisory decision by the tree arbitration board, this last section G, you talk about that if a party is going to bring a civil action, they should notify the Department of Conservation and Development. And I'm just wondering what role the department's going to have in any kind of private action. So what would the department be doing with that information?
Well, I think it's just to let the county know that this is happening. The county's not really gonna, as the ordinance is written now, they're not gonna be involved
Right.
in the litigation. It's just to let because if you've gone through the process, I think the county just would like to know that it's gotten to court.
Okay, thank you. Gail, does that cover your questions?
That's it for now. Thanks.
Thank you, Gail. Please lower your, thank you. And Michael Rossi.
Thank you very much. Actually, just more comments than anything else. Again, I think it's been a tremendous amount of work, Tom, and I thank you for bringing that forward, and John as well. The active maintenance allowances within especially heritage trees is pretty well defined within Sausalito. Most of the trees of Kensington, redwoods included, were planted prior to 1984 that are very large. Others after 1984 really do not meet the guidelines of a heritage tree. An arborist, when they are asked for any sort of input in regards to a tree dispute, is mainly there for a definition in Sausalito anyway, is usually utilized only for a, will this kill the tree? Can the tree sustain a cutting back of a certain amount? One of our neighbors planted a cork oak, which we knew could get to 60 feet tall. We requested a different species as it was planted. 15 years later, it is now in our view. So that was really our main coming to terms with this whole view ordinance thing. So those sorts of things as an advisory. One of the things that I'd like to see as an addition might be that as improvement or replacement of trees is done, there's a certain species guidelines to that. That would be another thing that was and is brought up in a Sausalito ordinance. And I may be getting them all confused. As I said, we researched about a dozen of these, and those were really very worthwhile. Heritage oaks, those sorts of things really define certain neighborhoods in regards to existing tree structures that were within California already. It doesn't really define someone's tree that was planted within their home, although after, as I say, before 1984, those things can be considered heritage trees. I think that being said, the maintenance of trees is something that can and should be allowed to preserve the tree itself, as well as an allowance of the tree to grow into a view. So sometimes these are relationship things with neighbors that are ongoing. In Sausalito, there's a lot of topped pine trees. There's a lot of topped redwoods. It's just a neighborhood that really has that sort of a characteristic. And as you drive through, you can see the plateau of trees as you go through the neighborhood. It's more of a character of the area as opposed to, it still feels very wooded. Spent a lot of time there and still do. So again, that's kind of the active role of an arborist in regards to definition. I would encourage those people who have view concerns to even offer to and encourage your neighbors who are in, that you have a concern with, to almost immediately involve an arborist to get those things done. Maintenance for fire is covered in every other level. These are things that California is not letting go. It's not going to be a part of this. I hate to muddy the waters with it, so any additions to that, I agree would be unnecessary to hear. The other, though, is the ongoing ability to then put within titles of properties the ongoing relationship of a necessity to maintain trees in a particular manner. And I think, again, those are things that are being outlined by arborists all the time. We had asked our neighbor if they insisted that a cork oak be left. It was a shrub of about 6 or 8 feet tall. We asked them to pollard the tree, which is cutting it, makes it really very structurally groupy, a lot different. Instead, their definition of a tree was big roundy bush, which just kept getting bigger. The interesting thing about trimming a tree is that if you just shave the exterior of it, it encourages growth to come out in shoots at every level, and therefore encourages the tree to consistently take over the view on an annual basis. The original planting of certain types of trees, especially oaks and other things, if done thoughtfully, you can maintain the trees at better structure, I think much prettier. I owned 14 acres in Los Gatos that had a lot of oaks between us and the view of downtown. When we came there, the trees were really scraggly and ugly. We had an arborist come through that did a very poor job. We then had, I think, one of the finest arborists in California, now unfortunately retired, but also an advisor to many cities, come in and shape the trees. They shape the trees with the intent of maintaining size. So I think, those are the things as a tree owner that I would encourage people as tree owners to require. This isn't just call someone in to shave the top of your tree off. This may be a bit of a setback to you on size or structure of tree for a bit, but the overall outcome to this is a happy neighbor. And I think you as a tree owner would be happier with better structure in a tree as well. So I think those are some of the kinds of things that we can encourage with this as an ongoing. Again, getting back to the ability to put some sort of an ongoing statement in title on a sale of a home or those sorts of things. I'm questioning how, especially to you, Tom, exactly how that would be carried through. It's nice to get resolution, but again, as these, and our properties are selling immediately. I mean, we bought them in Kensington and there was a rumor that over 65% of the people were over 65. It doesn't seem to be the case anymore. Lots of young families. Our national night out held at our house was 80 people came. Multiple new families are into these areas now, and our neighborhoods are changing rapidly. Houses are getting built bigger. So I'm just in regards to that question alone, Tom, How do you see that happening? What would be the process to that? If at any stage we have a resolution in regards to a maintenance of tree, maintenance of view, and those sorts of things, how would we ensure that those things are carried forward, that other neighbors could have me trim my tree or pay for trimming my tree, but then we can put them to guidelines of what has been decided on particular situations through sale or after sale. I think that's my main concerns for now. Thank you.
Right. Well, there's a provision in the draft that talks about final decision of the tree arbitration board can be recorded in the recorder's office. So I think that that's kind of that provides notice that this is what the tree board's decision was. So if one of the issues that the tree board decided was, well, or if it's something that the parties agree on, that, there will be this continuing maintenance obligation, then that would be on title if, as part of the decision that's recorded in the recorder's office.
And again, what about those of us who, and we would hope through most of this outline that it would be encouraged that just discussion with a neighbor would reach a decision on this. Would there be a pathway then that certain forms could be filled in, and this could be a documented resolution between a situation that would then stand through future owners?
It's a little difficult to bind future owners to certain things. Legally, it's problematic. I mean, I think about as far as we can go is actually saying that we're recording the final decision in the recorder's office. I mean, I think that if the parties agree among themselves that this is going to be a continuing maintenance obligation, I think they can do that, but then that's an agreement between the existing two property owners, and it's not really binding on future property owners. So, I mean, I think sometimes it's difficult to require, future owners of property to comply with an agreement that the prior owners had made with a neighbor.
Thank you very much, Tom. I want to just do a quick temperature check. As I understand it, we are over time technically. There are 3 questions still outstanding. This has been a great discussion. Can we continue or need we schedule another?
Let's hope to see if we can continue and just get this done today.
Thank you. Let's do that. Wendy, please.
Okay, thank you. I will try and be as brief as possible. I looked at this from a user's standpoint, so I just have a few quick suggestions, probably not part of the policy, although I'll be very interested. Sounds like Gail has been fielding inquiries over the years. So what I'm proposing is almost kind of think of it as a one-pager companion piece for people who call with questions, just to make sure that we are being consistent, objective, and specifically what I'm looking for is an overview of the levels or sequence of sort of how this works. So it's almost the intro paragraph. And again, this can be separate, not part of the policy, but I want to see, here are the 4 levels, or the 4 steps you can take. I also want to see at the bottom of that, the punchline, which is something around that phrase around, at this level, you can get sort of a rebuttable presumption. I'm probably not saying this right, but, here's what happens at the end, or, the very last level is, individual litigation. So anyway, just laying out those steps. The other is, for each of those steps, they talk about what needs to be submitted. I'd love to see either a template for each of those steps, or even just a brief bulleted list of here's what you need to include when we talk about people filing things. And again, Gail, I'm just thinking of you or people like you. you want to be really clear. Here's what we need to see at each step. Here are the 6 pieces of information you need to include, and templates would be awesome. If that's too much, even just the bullet. Also, and lastly, including URLs, websites, or phone numbers. We say things like, must be submitted with this county department. Again, as a user, please just tell me, who do I need to go to? Where do I send it? What do they need to know? So it's just a companion piece. I think the only sort of more specific piece around the policy question, do we need to, have there been problems specifying how do we prove, I moved in 30 years ago. What kind of proof do I need? What if I don't have a photograph? Does any of that need to be clarified, spelled out? So thank you, my 2 cents.
Thank you, Wendy. I'm not sure, do we need response on that, or do we go to the next question?
Well, I could just respond on behalf of the planning department even. They usually or often with ordinances have handouts once the ordinances are adopted, kind of explaining how things work. So, I mean, we would be able to work with them to do that. They have a lot of different handouts for different ordinances. So that's not a problem.
Wonderful. Thank you, Tom. Shira.
In listening to all this, it seems like one of our collective goals is to reduce litigation and associated costs and save people time and money and avoid silliness. One thing, so there are a few thoughts that I have on this. One is regarding Vantage Point. I'm aware, and perhaps some of you are too, that there are people who will stand in a certain corner of their living room and like this and take a picture, or some other weird angle. So I'm wondering if we can actually define what's a vantage point. What does that mean? Again, just like to avoid silliness. Second thing is extent of view. This is a similar thing. Trees grow. Do people have, are we protecting 100% of the original view? Are we protecting 90% of the original view? Are we protecting 50%? I just think, again, if that was, if it said 100% of the original view, it would, again, make things much more clear for the parties involved. I think the ambiguous areas just sort of invites litigation, and I think it would be better for all. Same thing with alleged view obstruction as a percentage of total view. If the total view was 80% to start off with, what are we talking about? Give people some, I think the more concrete we are, the better it will be for everyone. Similarly with soil stability, degree of slope. What does that mean? Can you please, add some degrees in there? Are we talking 90 degrees? Are we talking 3 degrees? It makes a difference. And the last thing I want to say is about the riparian aspect, which I started off with when we met today. We're all aware that there are underground creeks throughout Kensington. There's water constantly flowing down Westminster, for example, near where I live, and down Arlington, all year, even now when we've had 0 rain. And we've had some severe water issues, like when we had the big storm this last winter. So one thought that comes to mind is perhaps a map could be created indicating specific streets that are considered either riparian or riparian adjacent, where again, people would have more guidelines in terms of where things stand, where the value of the trees are in terms of holding the landscape together and protecting actually our neighbor's property from additional water damage in the event that the water level rises or we have severe storms, which goodness knows is possible. Last thing I want to say is I'm still not entirely clear about this issue of protected trees. I'm not entirely sure what can and cannot be done to them. I get the thing about a permit, but it's like, what? If an oak tree is on my property, I wouldn't be interested in getting a permit to have it cut down or trimmed off. So does that mean my neighbor has to get a permit to trim my tree? I'm not sure. I'm just asking this as a question. And I do like the idea of adding something to inform future owners. As I mentioned also when we started off, it was a complete surprise to me that this thing even existed, except my friendly neighbor came over and said, hey, it's that time again. And I'm like, time for what? So I understand that we can't bind future owners to abide by existing agreements, but what we could do, perhaps in some kind of legal way, is add to the disclosures and like mandate that this be added to the disclosures. Because if that was in the language when I bought the property, I could or could not have weighed in on how I feel about it. But the fact that I didn't know, that this affected the specific tree in my specific yard, it wasn't comfortable. And I'm sure that there's some way that we can do that, not to bind people, but to inform them.
Thank you, Shira. Tom?
Yeah, and I appreciate Shira. It's important to have the experience of someone in your position, because we're trying to make sure we craft an ordinance that works, right? So it's helpful to hear your thoughts. Let me just say, I think, Tom, this interplay with the heritage trees and all of that, can you talk about that more? I think that's so let's say if a tree that is grown to block somebody's view is a heritage tree, how does that affect the procedure, the process?
It's a heritage tree. I mean, that's protected under the tree preservation ordinance. So it would be kind of like we described earlier. You can trim those, you just have to go and get a permit to do that. So even if it's a heritage tree, doesn't mean you can't necessarily trim it. You just have to go get a permit from the planning department.
Who gets the permit then?
Well, generally, the property owner should go get the permit.
Arborists
because
get
you
them
can't,
all
you
the
don't
time.
you don't want to go get permits to do something on somebody else's property. I mean, the planning department, I don't even know if they would accept that permit application or not.
Tom, with our experience, that arborists get these permits all the time through the cities that they work in. They know which trees are protected within those areas. They cannot cut a tree on someone's private property without the authority of the person whose tree they're going to cut. And an arborist could be held liable for cutting a tree that is on a property that they do not have permission from. That being trees that rest on public property, they do need permitting to cut, especially certain types of trees.
Yeah.
Handed out readily by, say, PG&E or some sort of a thing in clearance of wires and other things. They're consistently going out with permits in hand to do whatever is needed to keep those sorts of utility and infrastructures clear at all times. But that being said, those sorts of things should be a part of your negotiation. You should have an arborist that makes those sorts of good recommendations. Barry Coates was the individual that I spoke about earlier, still actively involved in arborists. He sat on probably 40 different cities boards in regards to outlines of these, how to maintain trees. If he can't make a recommendation, certainly look at your local arborists, and they have some really great ways of managing those things. So
right. And we are talking about trees on private property, public trees on public property. Yeah. That's a whole different thing.
I wanted to.
Oh, go ahead.
Go ahead, Tom. You can finish.
You're right. I mean, it's a property owner or property owner's agent. So the arborist hired by the property owner could go and pull the permit.
I wanted to follow up on Shira's question about vantage point and what percent of the view. There were substantial discussions around that issue when we adopted the development view ordinance. God, it's been almost 20 years now. I was around for that. And yes, Tom, you were. Gail, you were, right? So in that ordinance, it was clear that this is different. It was the right to develop and balance views, but that you weren't protecting 100% of somebody's view, and there, it was all trying to minimize the impact on somebody's view, and then you weren't protecting, let's say, a view from somebody's bathroom in the same way you were protecting a view from their kitchen or their living room or their bedroom. And then there were issues about, well, if somebody had a pretty substantial view on the second floor, there were those issues. So there were some considerations into what's reasonable. I don't see any discussion of that in here. Am I wrong? How would that be treated? Because let's say in other words, what's the extent of the view you're protecting? And I do think that's an important issue.
Well, I think first, the difference between this and the Kensington overlay ordinance was, when you build something that's permanent, so that view is going to be blocked for all time. I think this, we didn't change much from the existing ordinance, because every kind of property is different, and every tree is different, and every view is different. So I think we left it as it was in the existing ordinance, just to be flexible to deal with different situations. I mean, I think when you go before a tree arbitration board, it's really going to depend on, what the nature of the view is that the person whose view is being blocked. I mean, is it a view from a bathroom, or is it a view from the deck? I mean, those are all things that are going to, be brought up during the hearing.
I would want to look at it too. Some of the other cities had prominent landmarks. Ours may be the Golden Gate Bridge, or some sort of a view of the city front itself from a vantage point. And those were given strong protection in regards to, say, windowing a particular area of a tree, as opposed to decimating a particular elevation of a tree to achieve an overall view of San Francisco. So the idea of getting and maintaining your view of the Golden Gate Bridge is iconic, and those sorts of things. I mean, we all buy our homes with the 3 and even a 4 bridge view, and those things have some status in regards to value. There's a Pacific Palisades court case that they put a $17 million valuation on the blocking of a view, and those things have been achieved. So there is some real value in regards to an actual view itself. Again, a view of the bridge as opposed to just a view of your neighbor's backyard. Certainly it's
well, in fact, that ordinance did make a distinction, the viewer, the development ordinance, saying, it's not like you have a view, your view into someone's backyard is not the protected, it's a distant view that's protected. But even then, it's like, so your view could be impinged somewhat by a development, but you still have the great view. So I'm just wondering how that plays into the tree issue here too.
Well, any sort of development has an envelope size, and Curtis could probably speak more to this than anyone, but in regards to the actual outlines, in regards to what you can build on an adjacent property, you can't keep someone who owns a piece of property next to you from developing their property in a manner that is already outlined and defined by that particular parcel. So you can't keep someone from putting a second story on a single story home, let's say, even though that may impinge your view.
I mean, part of it, how do you, Tom, think about what's a reasonableness standard about all of this?
I think that, I'm looking at what's in the draft of this ordinance, and then I'm calling up the Kensington overlay district ordinance, and the Kensington one does have more detail about what constitutes a view. But this basically, I'll just read the definition. It says view means a scene from a window in habitable space of a neighboring residence. So already that's a difference between the Kensington ordinance and the tree ordinance, because you might want to view from your deck, and the tree is blocking that. But then the Kensington ordinance goes on to say the term view includes both upslope and downslope scenes but is distant or panoramic range in nature as opposed to short range. Views include, but are not limited to, scenes of skylines, bridges, distant cities, distinctive geologic features, hillside terrain, wooded canyons, ridges, and bodies of water. So, I mean, I think that if that's kind of where the group is headed, we could add that to, you know, what to the section where we describe what a view characteristic is.
I think it makes sense to be consistent between those two ordinances, since there's both Kensington specific ordinances.
And I also feel like anywhere where we can add specificity will help everybody.
Yeah.
I think to get it too broad, though, means that someone wants their absolute view that they had when they bought the home. I mean, we've had neighbors that have been in our neighborhood for 60 years, and trees do grow. I think it's a very hard thing to protect, or possibly we're just driving things towards litigation at that point. So I think we have to be specific in regards to what a loss is as well.
Okay.
Yeah, so we do.
Tom, you'll make some adjustments.
Right. So yeah, we do define view in the current draft, but we can add a little bit more from the Kensington ordinance.
So we're so I'm gonna have Mark
Also,
comment. Yeah,
Mark,
and then I'm gonna try to wrap up because I have to move on too here.
Mark Wagner's been waiting patiently to ask his question.
Hi, thanks. Yeah, I guess my question / comment just echoes on some comments that have been made before about notification of future owners. And I mentioned before that the house in back of us is probably going to go up for sale very soon. It's being renovated, and it's got these trees which have been trimmed in the past by the previous property owner, who has now passed away, and it's owned by an absentee landlord, I guess you could say. And what responsibility does the real estate agent have for notifying prospective buyers? And how would the real estate agent be notified of this past history? Thanks.
Great. So I think it sounds like our best course of action is, this has been really helpful input, is for county council to sort of take this. Look, there's been some proposed changes, put together a new draft, and then we would quickly put a meeting together with regard to this, any changes. And then Tom, can you get an update of where, and I'll ask John Kopchik, my next meeting is John Kopchik from DCD, about where we are on the tree ordinance, because we may want to have an update about that, because there's some interplay between the two. You know, folks have raised issues, and get an update on that. And I'll ask John this afternoon as well, and then we can regroup here, try to reach some kind of consensus so we can move forward with this ordinance.
That sounds good. Yeah. Yeah, I think we can ask DCD, but I think it's useful for you to ask John as well. But yeah, so far we're going to change the definitions of tree, add a definition for arborist, and add some detail about into the definition of view, and then look into the solar panel issue in that law, the Solar Shade Control Act. I think that probably would be more useful in the revised overall tree ordinance than in this ordinance.
Right.
And then think about including some language to notify future owners. And I'm thinking that probably the way to do that is just as part of a disclosure, you know, and it probably has to be disclosed already, because you have to disclose what the zoning is, and that, you know, this is the TOV overlay zone. So people should know about this ordinance when they buy into Kensington.
Okay, and then, yeah, I think maybe have a list of what the other ordinances are on trees. And I do, you know, the issues on heritage tree, wildfire risk, all of those are important issues that hopefully will get addressed in another ordinance.
Also, I would just like to ask that we get a timeline for getting these changes and meeting again, because it would be really good to get this moving forward. I don't know.
Yeah. Tom, when do you think you'll be done? And we'll just set up a meeting as soon as you get us the new draft.
These are pretty straightforward definitional changes, so it shouldn't be too long. So if you guys want to set up a meeting, we'll have those changes by then.
All right, so hopefully should we just, this is a different meeting. Okay, yeah, well, this is, we're getting ready, but you can, we're out, we're gonna do it. Okay, oh, okay. We got meeting after meeting here. What do you want to just set up a time now? I mean, we could set a meeting up for later in September.
Yeah.
Yeah, we should be able to do that. Curtis and I can work on it, and I want to acknowledge Curtis and all the hard work he's done on this ordinance.
Okay, thank you.
Yeah, like, how's Monday, September 19th at 3:30 at 3? Well, let me see. I'm trying to make sure our sustainability committee is at 3:30 on the 19th.
Oh, you know what? I'm not available on Mondays, but go ahead without me.
I mean, the other possibility is Wednesday, the 21st at 3:30.
Does
that work for people?
That works for me.
Wednesday, September 21st, 3:30 p.m. Can that work for all?
Well, hold on, let me check. To minimize some screens.
Tom, I'm out that week. Just
the
21st?
Yeah.
Where will we be?
Wednesday, September 21st, 3:30 p.m.
Does that work?
It's not great for me. I don't know if I'll be able to come, but go ahead without me.
And what we could do as well, Catherine, is we would send you the draft ahead of time. And if you have some questions or concerns, you can email them to me.
Great. Okay. Thank you.
In fact, Tom, just on that, where is it? Let me just look at something.
I'm hearing no objections to September 21st at 3:30. So that's cool.
Well, Curtis will be out of the office, but I think I can handle it.
So how are we addressing the issue of how encouraging tree owners to plant trees that typically you don't block views? How do we sort of
You mean in terms of if you're going to fix somebody's view and fix it by taking out a tree?
Right.
I mean, we could add a statement saying, something like, the property owners are encouraged to plant, I don't know, shorter trees.
Yeah. Right. Okay. All right. We're good. So we'll have our next meeting on the 21st of September at 3:30.
Yes, thank you everybody for a great meeting and for your patience. Much appreciated. Also, I know some of you have already done this, but feel free to email any written feedback to me, and I can put it all together for Tom and John and Curtis to be able to review. So your written feedback is still welcome.
Okay, thanks everybody.
Thank you.
Thank you all.
Great work.
Thank you.
Bye now.